great experience, and can you hear me okay? I hope so. I don't know. Am I on? Okay. All right. Sounds good. And hopefully, they travel up there safely and come back home safely and have just a great experience. I know they will. Those girls have worked hard. The only downside that I know about this weekend is I'm going to unfortunately have to miss Darren Tackett's funeral. I would bet almost everyone here knows Darren. I want to just spend just a minute to talk about him, if that's okay. I was a defense attorney for 18 plus years, and he was obviously Iowa patrolman, and so I was defending a lot of people that he had arrested or lead investigating officer on, and got to know him really well through a professional aspect. I never got to know Darren super well on an individual basis, but on a professional basis, he was the best lawman I had ever encountered. I told him over and over again throughout his career that the Missouri State Highway Patrol missed a great opportunity, and that if they'd have let him teach the academy, they'd be the most respected law enforcement organization in the country. That man was the same whether you saw him at K Highway eating breakfast or whether or not he was in uniform. He was just a man that served with humility and passion and empathy, and boy, I hope that every law enforcement officer aspires to be like Darren Tackett. He was just a fantastic person, and because he was a fantastic man, it made him a fantastic law person. And so, I'm not quite sure. I don't know. Darren was, life's short. He had a lot of big plans after his retirement, and he came and talked to me in my office several times, and his retirement didn't turn out as he wanted it, but we all know he's in a much better place right now. He got to hug our Lord and Savior's neck today, and so I know that's where Darren's at. And but he was just a phenomenal person and just a great law person, and served our community as admirably as I've ever seen anyone do. So with that being said, let's talk about the Constitution a little bit. Last week we talked about the Articles of the Constitution, which is a general framework about how our founders set up our government. But one thing that was missing out of that was, and they talked a lot about at the Constitutional Convention, was, well, what about individual rights? And so after the Constitutional Convention, and after they ratified the Articles, they came back and they did 10 amendments. And the 10 amendments are called the Bill of Rights. I was again very fortunate that OSCA, State Court Administration, prepared me a slideshow for you all tonight. I cannot take credit for any of the slideshow because, again, I'm a dinosaur and could not tell you how to make a slideshow. But they were wonderful, just a great group of people that were excited about me giving this presentation to you all tonight, and helped me by presenting this presentation, which is entitled The Bill of Rights, A New Nation Makes a Bold Promise. The Bill of Rights is the name given to the first 10 amendments to the Constitution. They protect individual rights in a number of areas. After the Constitution was written and submitted to the states for approval, the Anti-Federalists opposed it. There were two primary objections, disagreements with the Constitution. There were no Bill of Rights, and there was too much power had been taken from the states. So again, you got to remember back in this time, late 1700s, they just got done fighting a brutal king, and they really wanted to avoid the problems that led to the Revolutionary War. They wanted to do this experiment, essentially to give people individual rights and not give all the rights to a centralized form of government. James Madison, the father of the Constitution, was opposed to the Bill of Rights. This kind of seems odd, right? Well, he didn't oppose the individual rights, that wasn't it. Instead, he believed if we wrote the rights down that people would possess, then we would not enjoy any other rights that were not written down. That's what he was scared of. He was very worried that, well, if we make a list, then that may be all the government will recognize. There's got to be more. We can't just make a list of all the individual rights that we all should enjoy. Madison knew times would change, and he did not want to limit individual rights to what we recognized in 1791. He understood, and he was hoping, as well as the other framers, he was hoping that this Constitution agreement amongst these states was going to last for a very long time, and they had to try to predict the future. And he knew that society would evolve and change, and he did not want to simply list. So that was why he was opposing it. New York, a key state, claimed it would not ratify the Constitution unless a Bill of Rights was added. Ultimately, a Bill of Rights was promised to be added, and the Constitution was ratified. So when they were there trying to get the article signed, New York, some other states said, we won't sign this unless we all agree we come back and we do a Bill of Rights. And they agreed upon that. In 1791, the Bill of Rights was proposed and ratified by the people, officially becoming a part of the Constitution. So let's look at the first 10 amendments, which is known as the Bill of Rights. The First Amendment states, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. Well, isn't that important tonight? There was very few times in history where people could freely congregate and worship. That right here allows us to be here today. Or abridging the freedom of speech, or of the press, or the right to the people to peaceably assemble and to petition the government for redress and grievances. There's a lot to that. That's a big First Amendment and incredibly important. So let's kind of talk about why the First Amendment, what it protects, and why is it so important. And all of these rights are important. And as I kind of talk, I'm going to try to do my best to relate it to this as how the modern times are, because one of the oaths that we all have to take, we talked about last time, is we have to defend the Constitution. We have to uphold the Constitution. And the moment that we as society stop upholding the Constitution, our government will end up being tyrannical. That's just the history. That's just what happens. If you give all the power to a government, they'll eventually oppress. And so you have to always be guarding the Constitution and protecting these rights, even when it's for people that you do not agree with. So let's talk about this just a little bit. I'm going to break these things down. So how many people think that the Constitution has the word separation between church and state? Right? So unfortunately, it kind of cringes me whenever I go back or I hear how things are taught in schools sometimes or other places, and they say, there's a separation between the church and state. That's not in the Constitution. Instead, that was a letter titled by Thomas Jefferson, Separation Between Church and State. And Justice Hugo Black in the Supreme Court case Everson versus Board of Education essentially made that a part of our modern day thinking when it comes to the First Amendment and the Establishment of Religion Clause, when he wrote, this clause intended to erect a wall of separation between church and state. That was in 1947. And in that case is, if you go back and read that, and that is the Everson versus Board of Education, and he talks about a wall that, look, there should be a big giant wall between government and religion and the church. They shouldn't be intermixing at all. Well, I ended up writing my senior thesis in college over this. And from 1947 to 2001, there was a series of cases where they put a window in that wall, then they put a door in that wall, and now that wall is pretty short. We have all kinds of mixing between government and religion now. It's still, the wall's still there in aspects, but it's not to the extent that it was what Hugo Black thought it was going to be in 1947. The Supreme Court has taken down that wall fairly extensively, in my humble opinion. But that gives us this right to be here today, and it's probably good that religion is not part of our government. I think that's a very wise part. You don't want our lawmakers imposing maybe their religious views upon everyone. May be different than ours, maybe different than someone else, and that's one of the freedoms we enjoy in this country. We get to be here. Someone can be down the street worshiping how they choose to worship, and that needs to be protected. We're going to talk about this a little bit, but I'll mention that in just a second. The other one is the freedom of speech, or bridging the freedom of speech. That's going to be a really hot button topic, and was the last several years. What about online speech? What about who gets to post stuff on Facebook or Twitter or Instagram? What happens if a government agency coordinates with a company or corporation to silence people that have views that that they don't like? That's going to go through the court system. There's thoughts on it. Does that violate the Constitution? We don't know yet. The Supreme Court hasn't weighed in on that. That's going to be coming up in the very near future. One argument would be as well, Twitter, Facebook, they're a company. They get to decide what should be on there, what shouldn't be on there. And if they want to listen to government, and the government says, hey, I don't want you letting so-and-so post on this, well, that's up to Twitter or Facebook or whatever company, whatever other online. Or we shouldn't have our government coordinating with people to silence our freedom of expression and speech, right? So you can see where there's two different tug of wars there. You have a right to a corporation that may have the right to be able to, I could put whatever I wanted to on my platform. Or do we really want our government meddling and trying to silence people who is posting stuff online? That is something that is going to be, I believe that's something that will be in the courts in the near future. Going further in this amendment, or the press, or of the right of people to peaceably assemble. Let's talk about our COVID years. What happened in COVID? What was the government telling us then? Could we peaceably assemble then? Well, we could if we were probably someplace in a city, rioting someplace maybe, right? We're in Ripley County. What was the government telling us? Were we supposed to have church back in 2019? Right? I cringed during the COVID years. I mean, it was, the right to peaceably assemble. What happened during the COVID years? Or COVID months rather, whenever the government was saying, nope, you can't do that, you got to stay home. You can't be amongst a group of so many, right? Was that lawful? Was that something that maybe was not constitutional? I don't know. By the time it was be litigated, a lot of those things were lifted. The wheels of justice move slow in the court system, and it does that for a reason. But something interesting to think about is that you have to guard and protect those rights, and even during times of turmoil, you have to be able to protect those rights, because next time they may have another reason to keep us from assembling peacefully. So that's got to be something that's guarded very well. The First Amendment empowers individuals to think for themselves and make their own decisions about their religion their political beliefs, what they learn, their morality, their culture preferences, and their interaction with the government. Leaders of other countries looked at our First Amendment and reacted with disbelief and astonishment. They asked, "You are going to allow people to think for themselves and speak their minds? The way to control your people is by controlling what they say and believe. Your First Amendment stands in the way of doing that." Now, I intentionally waited until to talk about the freedom of press. That's what other leaders were saying back then. Why is the freedom of press so important? It's so that we have the information necessary so we can form our own opinions and vote accordingly. That's why that freedom of press is so important. Even when press has writing articles we may not agree with, we still have to have a full freedom of press for us to be knowledgeable, not to be controlled by narratives, but to have knowledge and information so we can make informed decisions as the electorate. And at that time, our framers responded, "We are going to do things differently in our country. People will be free to think for themselves." And that's kind of the basis of the First Amendment. We have to be free to think for ourselves, because if we are controlled, then someone's controlling us, and it's usually for a purpose that's not for our benefit. All right. On to the Second Amendment. The Second Amendment, for much of its history, the Supreme Court interpreted the Second Amendment as only protecting the possession of weapons in relation to service in a militia. Well, why is that? Second Amendment states a well-regulated militia, comma, being necessary to the security of a free state, comma, the right of the people to keep and bear arms, comma, shall not be infringed. Well, there's been some different interpretations on that right? As this slide indicates, the Supreme Court interpreted that initially, or sometimes, believing that that amendment only protected the possession of weapons in relation to service in a militia. So if you were in a militia, you got to have guns. Otherwise, you really didn't. However, in recent decades, the Supreme Court has interpreted the Second Amendment as protecting the right of individuals to possess guns. And there has been two landmark cases in what I would consider recent history, that being in 2008 and 2009, the District of Columbia versus Heller and the McDonald versus City of Chicago. Both of those cases involved laws in which handguns were banned. District of Columbia, you couldn't own a handgun. District of Columbia couldn't have a handgun. And Justice Scalia wrote the opinion in the Heller decision, which decided in a narrow decision, decided that, and it recognized, the Heller decision recognized the individual's rights to possess firearms for self-defense purposes. That's why that was such a hot button topic back in 2008, 2009, 2010, is that the Supreme Court recognized our individual rights to possess a firearm outside of that of being in a militia. That's why there was a lot of gun rights talk about legislation at that point in time, and that's why it was really a hot button topic back then, that Heller decision. And then later, the McDonald versus City of Chicago decision, similar case, broadened that a little bit. Broadened that says, yeah, the federal government can't do it, and neither can the state or local governments infringe upon those individual rights. Those are two extremely important decisions in our nation regarding the Second Amendment and your right to bear arms. Now, the Third Amendment states no soldier shall, in time of peace, be quartered in any house without the consent of the owner, nor in time of war, but in a manner to be prescribed by law. Now, I think we got to understand the historical, because it's hard for me to wrap my brain around this. But back then, the Third Amendment was not designed to prevent the recurrence of one of the most despised British practices, which was quartering British soldiers in the homes of colonists. That's hard for me to wrap my brain around, right? But could you imagine, instead of having Fort Leonard Wood, hey, we're going to have 5 soldiers sleep with you tonight, right? Isn't that kind of hard to imagine? We was like, yeah, no, this is my house. Yeah, no, this is my home, not the government's home, right? If we didn't have the Third Amendment, we may not have military bases, or our military bases may look totally different, may not have living barracks. They may just say, yeah, we'll camp up, we'll put up right outside of a city, and we'll just have all of our soldiers quartered by the general population. It's just hard for me to wrap my brain around that. It also sent out a strong message about the sacred nature of private property and the limitations on government power. There's the home is the castle, and that's talked about a lot in Supreme Court cases, and they use this amendment as one of the bases for that is that we have a right, we have certain strong rights in our homes, and we have a strong expectation of privacy in our homes. And the Third Amendment kind of helps establish that, among other amendments. The Fourth Amendment. Now, this is one that I deal with on almost a daily basis as your associate circuit judge. The Fourth Amendment reads, "The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the person or things to be seized." You've got to have a search warrant, okay, to be able to come in and to take things from us. Prior to this, the Fourth Amendment was a reaction to the abuse of power by the forces of the king. So say there is, and I want to put this in context so that I deal with on a daily basis. Say there is a house that is on a county road that has frequent traffic that goes in and out of it at all hours of the night. And it's noticed, and the neighbors notice, that people stop in there and they are there for about 5 to maybe 10 minutes and leave. And a police officer happens to pull someone over, and that leaves the house for some type of traffic violation, and they have some kind of controlled substance, say methamphetamine, okay? Well, they just left that house. Well, does that mean that officer can just like, okay, we're going to go in and I'm going to kick the door in that house and I'm going to go search that house, see if that person, if there's methamphetamine in that, because I think there is, right, if you're a law enforcement officer. Can a law enforcement officer do that? They can't, and it's because of the Fourth Amendment. Instead, they have to fill out a search warrant, and it's got to be by oath and affirmation based upon probable cause. And so I will receive a search warrant application with an affidavit attached that'll spell out what the officer has seen, what the officer has investigated, and then I have to review that, and I have to look on as what they call the 4 corners of that document. Based upon the information within that document, is there probable cause for the issuances of search warrant? If there is, then I have to narrow that search warrant to the place and the thing to be searched. So it's got to include the address of the house and what are you searching for in the house. We don't allow what they call fishing expeditions in a home. I'm going to give a search warrant and say go into the home of Jane Smith and John Smith and search for whatever you want to. No, you got to tell me what you're wanting to search for, and your affidavit has to be narrowly tailored. So in this instance, if they were to fill out an affidavit, an application, a lot of times in this particular situation, they made the traffic stop. The person at the traffic stop may have made a statement that, yeah, I just bought methamphetamine from Jane and John Smith, or whatever, Jane and John Doe. And that would be part of the affidavit. Jane and John Doe's address is whatever drive in Ripley County, Missouri. And then I'm requesting to be searched this home, and I'm searching for controlled substance and the paraphernalia of the controlled substance, whether that be scales, baggies, things, everything else to be used for the distribution of controlled substance. Well, if I review that and I find that there's probable cause, then I sign a search warrant as a judge. They can't go in there without that into someone's home. They go in, if I do that, then they have to go in, or they can then go in to the home and then search the home. But without that search warrant, that'd be a violation of the Fourth Amendment. That protects our home. Now, there would be some people who's like, well, that's crazy. Why can't they just go in? If they know the drugs are in there, just go in. We have to think about it from a different standpoint. The Bill of Rights were designed to protect us from tyrannical government, so that there is a process and there a procedure that the government has to go through before they can enter our home. And that's got to be for everybody. It can't just be for some. It's got to be for everybody.
So, but if the officer were to go into that house and found other things that were not on the search warrant, those would not be admissible?
It depends. That's a whole law school class on that. I wish I could tell you, but there is no easy answer to that. It depends. It depends on whether or not something is in plain view. It depends if the thing to be searched, say, is a very large item. Say they're looking for a rifle. Okay, they think a murder weapon is a .30-06, and I've signed a search warrant to go in and search for a .30-06 rifle because the person who was the shooter was seen to have a .30-06. Well, they go into home and they open up a glass case. Well, do you think that glass case could hold a .30-06 rifle? Right? They're probably not authorized to look in there. Does that make sense? I mean, that's a really big area of the law. But that kind of gives you a context of it. So that's a yes and no. Okay. But if they're walking around and they see and they're looking for the murder weapon, and they happen to see a pound of fentanyl on the kitchen table, yep, they can seize that. Okay. Does that make sense? This also applies in I could talk about the Fourth Amendment for a very long time because it is so important. But this really limits the government's power in order to take things from us, to stop us. They can't stop you and say, hey, let me see essentially your papers, or I just want to search you because you look suspicious, okay? You look like you're up to no good, come here. Can't do that. The Fourth Amendment prohibits unreasonable searches and seizures and requires probable cause to obtain a warrant. I don't know how deep to go in the Fourth Amendment. That's probably good because I think I'm going to run out of time. But the Fourth Amendment is you can talk in constitutional law an entire semester about. There's so many different aspects to it. But just understand the Fourth Amendment is what protects us from the government from taking things from us and searching us. They have to go through a process and make sure they have to have probable cause to do it. Leaders of other countries look at our Fourth Amendment and reacted in, again, disbelief and astonishment. They said, unreasonable searches and seizures. Unreasonable searches and seizures. There is no such thing as unreasonable searches and seizures. If the government wants to do it, it is there by the very nature reasonable. That's how it looked at the time. And we responded, we're going to do things differently in our country. The power of the government to engage in a search and seizure will be limited. And that is something that I deal with. My criminal law docket is every Wednesday. I deal with the Fourth Amendment whenever they call me at 1 o'clock in the morning and they're wanting a search warrant, whether that be, Judge, someone has had a wreck out here on Highway 21 and has ran and hit someone head on. They have an odor of intoxicants coming from them. They're badly injured. They're slurring their speech. There was a bottle of vodka in the passenger seat, and we want a search warrant to search their blood. Take a blood draw, right? Can the government just come and just stick you with a needle and take your blood? No. Instead, and that's been that was heavily litigated in this state for about 20 years. At one time it was when you were driving, you were consented to it. Now there has to be a search warrant. Again, I get those calls, on a DWI and request for a blood draw, or, hey, we have someone, we believe there's, drug activity at a certain house located, and we ask for you to come down and review a search warrant. That's a big function that I have as your Associate Circuit Judge. Moving on to the Fifth Amendment. No person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury, except in cases arising in the land of naval forces or in the militia, when in actual service in the time of war or public danger. Nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb. That's known as double jeopardy. Nor shall be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation. Another very important amendment, as they all are. I deal with this all the time as well. This is on a daily basis as your Associate Circuit Judge. We don't do grand juries very often in Ripley County. It's very rare. Instead, we have what they call preliminary hearings. And in our state, if a person is accused of a felony, it's a two-phase process. The first phase of the case, you have to go in front of an Associate Circuit Judge. And that's what I do every Wednesday afternoon at 1 o'clock. I have preliminary hearings. And at that hearing, the state of Missouri has to show that there's probable cause to believe that this defendant has committed the crime. If I find that there isn't probable cause, then the case is dismissed. Okay? That's what our preliminary hearing kind of takes place at the grand jury. That's also what a grand jury does. A grand jury can be convened, and what that is it's like a little mini trial, and the government has to present evidence to the grand jury to determine whether or not this person may have committed a crime. Is there evidence here? It's kind of a gatekeeping function for us to be able to try someone to a jury trial or try someone that their life or liberty is at stake. There has to be evidence of it. Well, that's a probable cause determination, and that's either got to be determined by a grand jury or by a judge in a preliminary hearing, so that we don't just file charges and just have show trials. Okay, there's got to be a basis. There's got to be evidence in order to present to a jury. That is critically important. Also, the double jeopardy. We've all heard about that throughout our lives. If you are charged with a crime and you go through and have a jury trial and a jury finds you not guilty, then you can never be tried again for that offense. The government gets one shot. They can't keep going after you over and over again. In fact, they can't go after you twice. They get one shot at it. In addition, no person shall be deprived of life, liberty, or property without the due process of law. Well, what's the due process of law? Well, it's the right to have a hearing in front of an impartial judge or jury. Okay? And in addition, the last part is very important, nor shall private property be taken for public use without just compensation, eminent domain. We heard about that very recently in modern times. So what if, I try not to personalize it, but what if the government decided they wanted to build a new penitentiary right out here on Jerry Clynn's property? Think they could just go out there and take it and say, we're just going to take it. Appreciate it, Jerry. It's a really beautiful piece of property you got out here. Can we take it? No. They'd have to go through a big, long process, and they have to pay him. And there's a whole statute that's designed for that. And I say that because I think he's got one of the prettiest pieces of property in our area. Just gorgeous going outside of town. But that's what that eminent domain, and the government can't take our property without compensating us, is there in the Fifth Amendment, and that's what protects us. The Fifth Amendment's requirement of grand jury indictment and due process of law and its prohibition against double jeopardy and self-incrimination were revolutionary at the time. And I failed to mention that. No one can be compelled to testify against themselves. I restate that, I don't know how many times every Wednesday morning when I give people their rights. So anytime someone's charged with a crime in front of me, this is exactly what I tell them. Ma'am or sir, you're entitled to a trial. At the trial, it will be the state's burden to prove you guilty beyond a reasonable doubt. At that trial, you will have the right to confront and cross-examine the state's witnesses. You will have the right to testify, but no one can force you to testify. And that line comes from the Fifth Amendment. No one can be forced to testify. You can't go up there and be compelled to be a witness against yourself. And nor can a jury if you choose not to testify against yourself, the jury cannot make a determination or use that as an inference of guilt, okay? Because we're all presumed innocent until we are found guilty beyond a reasonable doubt, and a jury cannot use it as a basis of evidence if someone does not testify. Leaders of other countries looked at our Fifth Amendment and again reacted with astonishment and disbelief. They asked, where is the logic in prohibiting self-incrimination? What better way is there to obtain a confession than by cutting off a suspect's fingers until they admit their guilt? And we responded, we are going to do things differently in our country. Government will not be allowed to torture its people. That Fifth Amendment, is, as with all these, are critically important.
That Fifth Amendment in self-incrimination is for criminal only.
Yes.
Not civil.
Correct. Yes. Only when your liberty can be taken from you or your life. It does not apply to civil. Now, in the civil aspect, in a case, you can invoke the Fifth Amendment privilege in a civil case. But then an inference is then used that says that if the person had answered, that answer would have been adverse to him or her. So it then can be used as evidence, and it's a rule of evidence. They get an adverse inference in a civil case. Still, if someone can invoke their Fifth Amendment privilege, but they may have to do it on the stand, versus in a criminal trial, they don't even get to the stand. Justice William O. Douglas speaks for many when he wrote about the Fifth Amendment. The Fifth Amendment is an old friend and a good friend. It is one of the great landmarks in man's struggle to be free of tyranny, to be decent and civilized. The Sixth Amendment is known as the Fair Trial Amendment. The Sixth Amendment reads, in all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature of the consequence of the accusation to be confronted with the witness against him, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense. So again, the thing that I read every single Wednesday, no telling dozens of times the people who are charged, is because of the Sixth Amendment. I have to advise them of their crime. I read them the exact information or complaint that's read against them and say something like, sir, the state of Missouri alleges that on or about January the 6th of 2025 in the county of Ripley, state of Missouri, you did allegedly possess a controlled substance, that being methamphetamine, against something of that nature. I have to advise them of what and on the information, it's got a list of witnesses. So they understand who is making these charges against them. And then we go through the colloquy, as I just mentioned to you earlier. The other one is the right to assistance of counsel for defense, public defenders. Now that has been determined that only applies to cases in which your liberty is at stake. And so if someone is charged with a crime in which it's just an infraction or a D misdemeanor where it can be only a fine offense only, you're not entitled to a defense. But if you are charged with a C misdemeanor or anything above that in which jail time is a possibility and you can't afford an attorney, one will be appointed to that person. Now, there is cases out there that says that the prosecution can state to the court that even though, say it's an A misdemeanor, say it's a DWI second offense, or no, let's put this, a careless imprudent driving, A misdemeanor, or failure to drive in the right half of the roadway. And Matt Michelle may get up and say, Judge, I'm waiving jail time, meaning I'm not seeking any jail time in this case. Well, then there's case law out there that says that person's then not entitled to representation. If they want representation, they go hire their own attorney, but they don't get one appointed to them. That is our Sixth Amendment. Protections such as the requirement of a speedy and public trial, the confrontation of witnesses, and the assistance of an attorney prevented show trials where the outcome is certain from the beginning. The other important part of that is that the jury has to be determined by the district you live in, okay, or the district where your case is being held. So say in Ripley County, if you're charged with a Ripley County case and the case is being held in Ripley County, we don't go get Butler or Howell or Shannon County people to come sit on our juries. No, it's Ripley County folks going to sit there. But we have a change of venue because sometimes you may have a bad reputation in your county, or it may be highly publicized, right? Maybe all over the DAR, Prospect News, or Facebook, and get me to St. Francis County, or Greene County, or Cape County. I don't want this highly publicized case here heard in Ripley County. And so that's part of the due process. You want to make sure you have a fair and impartial jury that gets to hear your case. Leaders of other countries were once again in disbelief and astonishment. Boy, they were really disbelieved by us, weren't they? They said, let us understand this. You want to successfully prosecute someone you believe to be a criminal, and yet you are going to inject into the process an advocate who interferes with a successful prosecution? And we responded, we are going to do things differently in our country. We will not allow people to be convicted without proving its case. So the government's held to a high standard. Without that, protections, and you got to think about it. And this is where, when you hear someone say, well, so-and-so was got off that case because of a legal technicality, right? We've all heard that several times. It's really never a legal technicality. It's usually because their constitutional rights were violated, and that's hardly a technicality. It's usually that somehow their Fourth Amendment, Fifth Amendment, or Sixth Amendment rights were somehow violated. They weren't advised of their rights under Miranda, which is a culmination of the Fifth and Sixth Amendment, their right to an attorney, their right to remain silent, and anything they say can be used against them. So that protects people from being arrested, protects us from being arrested and getting false confessions from the government. Can't do that to us because of those protections. And so the amendments are there and the Bill of Rights are there to protect us from a tyrannical government. The moment that let's bend that because we really know John Doe was guilty of that. We don't ignore the Fourth Amendment right there because we know he's guilty. You can't ever go down that road as a society because next time they'll use it against someone that may be innocent. Or we as a society always have to hold the government to their standards and to the Constitution and to their level and to their burden of proof. Okay, the Seventh Amendment. The Seventh Amendment. In suits of common law, where the value and controversy shall exceed $20, the right of trial by jury shall be preserved, and no fact tried by a jury shall be otherwise reexamined in any court of the United States than according to the rules of the common law. The Seventh Amendment extended the right to a trial by jury in federal courts to civil cases. Essentially, if you had a controversy of money, you could have a jury of your peers make a determination. So we see that a lot of times. Say a car wreck case, you have a right to a trial. You don't have to have me or some other judge make the determination. You can if you want to, but you can have, and if you're suing someone, say from the state of Illinois, and the controversy is more than $75,000, you can have that tried in a federal court. So we see that quite a bit in, say, a let's give a reference. Say there's an 18-wheeler that is coming, that's owned out of Texas, and they run a stop sign and run over one of our residents here in Ripley County, Missouri, because the guy fell asleep and he was driving too much, because the corporation was saying, you need to be, you got to make that haul today, and that's in violation of his hours that week. Well, there could be there could be a big case, right? That could be $1 million case or more, because life is, you can't put a value on that. Well, that person may not want their case heard in Ripley County. They may want to hear that case in front of Magistrate Abby Kreitz-Leone or in front of Judge Limbaugh in Cape, because the controversy then would be between a resident of Ripley County, Missouri, the survivor is the person who was killed in the car wreck, and they may be suing the trucking company that had their driver driving too many hours in a day and fell asleep and killed someone. So that controversy will be more than $75,000, involves people from 2 different states, so that allows them to sue in federal court. And that 7th Amendment allows that. Let's see here. The 8th Amendment. The 8th Amendment prohibited cruel and unusual punishment. This is a hot button topic. This doesn't get as much press as it used to, or maybe I don't watch as much press as I used to, but the 8th Amendment says, excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. This always goes to the death penalty cases. And so that's kind of important right now, is that so many states were using the death penalty and imposing it through lethal injection. Well, there's some doctors out there that were claiming some of the medicines we're using that essentially made someone catatonic was causing great pain to them. So that was being heavily litigated in the court. So that protects us from cruel and unusual punishments. Is that a cruel and unusual punishment? That's how it's kind of relevant to today. We still have the death penalty in the state of Missouri, but it's not used. It's not imposed as often, I think, as it once was. Leaders of other countries looked at our 8th Amendment again. They were just in disbelief and astonishment. They asked, what better way is there to compel the public to follow the law than to punish a lawbreaker with savage cruelty? It teaches everyone to obey a law or face extraordinary consequences. And we responded, we are going to do things differently in our country. Government will not be in the business of engaging in savagery in order to teach lessons to its citizenry. The 9th Amendment, and that's already 729, so I gotta go quick. The 9th Amendment was designed to address Madison's concerns about limiting the list of rights available to the people. Ironically, judges have been very hesitant to use it as a recognized additional rights. This 9th Amendment states the enumeration in the Constitution of certain rights shall not be construed to deny or disparage other rights retained by the people. I can't think of a single case that the 9th Amendment has been used to show grant us another right. There probably is, but my constitutional law class has been a little while. And finally, the 10th Amendment. The 10th Amendment states, the powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states, respectively, or to the people. The 10th Amendment was designed to address concerns of the anti-federalists and to ensure states an important role in governing the people. These ideas, which were added to the Constitution in the 18th century, continue to guide our resolution of issues in the 21st century. Ladies and gentlemen, that's our Bill of Rights. Does anyone, and it's 7:31, so I did better this time. I didn't go as long. Does anyone have any questions for me today?
Before we ask, some people have been watching online. They've not been able to hear the questions, so if you don't mind, use a microphone. This will allow the people online to hear the question.
In the First Amendment, it stated that they have the right to peaceably protest. But lately, you hear all these people that are breaking things and ruining things in protests, that they have a right to protest. And how has the judges ruled on that? Because
Peaceably is the important part.
Yes.
If you're looting, rioting, breaking windows, things, I think courts have found that that's not peaceably. Now, whether or not the executive branch enforces that by arrest or not is something different. So the executive branch is what enforces our laws. Whether they choose to enforce those laws is within the discretion of the executive branch. But that is more there for if we peaceably assemble around a flagpole to pray at the beginning of the school year each year, they can't come and arrest us. Does that make sense? We're protected because we have the right to peacefully assemble. Okay? Great question. Anyone else have a question? Yes, sir.
I've always questioned this one for a long time. On the Fourth Amendment and game wardens not having to get search warrants, I've never understood, because they're a law enforcement agency, and I've never understood why they can go on somebody's property and do what they do without a search warrant.
Well, that's a really good question. Probably one that I probably shouldn't talk about because it comes in front of me quite a bit. So I probably can't talk about it too much. But that is a heavily litigated issue, sir. Yes, there's a lot of people that have those concerns, and there's also people who say, well, when you agree that you are going to hunt one of the animals that are game animals. That are under the aspect of the Conservation Department, you are agreeing to abide by the rules and regulations, and you just kind of sign a contract when you get, that's the legal argument, you sign an agreement whenever you get the privilege. Because it's not a right, it's a privilege to get to hunt. That's the courts have determined that, and so part of that privilege comes with strings attached. That's the theory or the argument.
I mean, it seems to be United States wide. I don't think it's a Missouri.
Correct, it's not. That's correct.
It's but I've just never understood it. Also, a couple years or so ago, the FBI had showed up at some people's houses in Missouri asking to see the guns they just purchased, and I think our Attorney General wrote Merrick Garland, the Attorney General, and argued for him too. Do you know anything else? I mean, all I heard was the surface of that, but I've not heard.
I don't.
The politics of it was our Attorney General wrote the letter, but I've not heard anything else about that.
I unfortunately I don't. I mean, if just, but so there's nothing in our Constitution that prevents federal government or a law enforcement officer going and knocking on our doors. And because if they say, well, you know, your front door is open to the mailman, your front door is open to guests and invitees. Now, unless if you do something to barricade it, which we had those cases in Ripley County and all through rural Missouri. You know, someone has a fence up and a gate and with big private posted, no trespassing, right? There, the federal government probably can't cross that, or the law enforcement without what they call the curtilage of the home without a warrant. But say they come in Sunny Acres and they want to come up and knock on someone's, door. Well, that's kind of, there's not any no trespassing signs, and people can do that. So the federal government can do that, or law enforcement can. A lot of that's called what they call knock and talks, and those have been litigated heavily. A lot of times, and that's a very common law enforcement tool. They go and they'll knock on the door, and then they'll talk, and then sometimes that leads to, hey, can I come inside? Well, sure, come on in. Well, that's not a violation. If you're invited in, they're invited in. You're not going in by compulsion. So if they're invited in, and then they're invited in, and all of a sudden you see a pound of fentanyl on the kitchen table, they can then arrest that person because that law enforcement is someplace lawfully they were allowed to be, and something was in plain sight that was in violation of the law.
It seemed like part of the argument in that particular one about the FBI was that how did they know that they bought the gun because they're not supposed to keep any records? I mean, I'm a little confused on that. Do you know anything?
Unfortunately, I don't. I don't know how the ATF keeps those records and who has a right to them. And I know there was a big, there's been talked about legislation about making us register our guns and things of that nature. And so, I can't really speak of it too much on that. I wish I could.
Any others? now's the time, and we've got him here. So,
Well,
we'll put him in jail until we're done with questions. How about that?
I see out there, I think I know about every single one of you, and so please, I don't be a stranger. If you have a question for, ask me. You see me in the restaurants.
Which one of these have you seen in court?
None. Now, I see Miss Carnes at basketball games a lot. No, but if I do see you in court, you'll see a friendly face. But you see me out, ask me a question anytime. I try to be I've tried to be the same person as I was before I was a judge, after I'm a judge. And so I hope I'm approachable. I hope if you see me out and about at a basketball game or in a restaurant or anywhere else, I hope, and you got a question, I hope you feel free. Now, I can't ever give someone legal advice, but I can answer questions about what the law is, okay? Again, thank you so much for having me. I've really enjoyed both these presentations, and I know Oscar will be happy with me that I gave presentations. And so again, thank you very much, Pastor. Appreciate it. Thank you.
Thank you for your willingness to come. Let's thank you all for coming. Let's go to the Lord in prayer. Father, again, we thank you for these United States of America, and we thank you for founders like James Madison and many others that you put into their minds to create a document that gave us these United States. Father, help us 250 years beyond to continue to protect that and to cherish it and to uphold it. Father, help us as believers to always pray for our nation. Lord, we know that you gave us this nation. If there's ever a nation outside of Israel that's been ordained by you, and we know that you raise them all up, but if there's ever been a nation, it's been the United States. The amount of freedom, the amount of people across the world even, that's because of this nation and the wealth and that's been contributed across the world. Lord, this nation you have used. The amount of missionaries that leave this country and go. I know the Southern Baptist Convention, Lord, you've raised up, there's over 4,000 Southern Baptist missionaries, not counting all the other denominations and churches that have missionaries all over the place that take the gospel. The amount of Bibles that get sent to the uttermost parts of the world that they might hear your word and have within their hands copies of your sacred writ, Lord. We thank you. Again, you've used America. The liberty and the freedom again, the world wars, how you've used our nation, how you've used our nation to stand against communism and against atheism and against the cruelties of other nations, Lord. God, help us to never lose our way. But Father, we've been heading in the wrong direction for a long time, much of which our Supreme Court has done. Removing the Bible, removing prayer, which our founders thought necessary to be in schools and to be in public centers. One of their first acts was to buy Bibles. Lord, help us to just not lose our way. Help us to, and I forget which one, maybe Adams, who had said that our Constitution was written and is only suitable for a righteous people or a holy people. And so, Lord, some of the complications we have, we can't help but think that it's because of our abandonment of your word and your principles. God, help us, and we're the holders of that, Lord. You, the church, your people, those called by your name. Father, you tell us and remind us that judgment begins in the house of God. So, Lord, help us to be faithful to you. Help us to humble ourselves and seek your face and turn from our wicked ways, knowing that you'll hear from heaven and forgive our sin and heal our land. Father, we've seen you work through the Great Awakening, and We've seen you work in the Second Awakening and the New York Awakening. Lord, we've seen multiple accounts where you've just done magnificent work, and even more recent in some of our colleges and universities. I think it was Ohio that just had scores of college students come to know Christ, and Tennessee and Texas and other places. Lord, we pray that you just continue to move. And Father, we would ask that you might bring that here in Donovan, that you would have a great move. God, help your people, those called by your name, the ones who know you. And Lord, you tell us in your word there's only one way that we can know you, and his name is Jesus. So help us, Lord, again, to be faithful to you, and help us to do our work to the degree that Judge Kirby doesn't have a job, because the crime would be eradicated because of your goodness and your grace. I know that's far-fetched, but you're God. And that shouldn't stop us from striving to win as many people as we possibly can to Jesus, because that's the greatest thing that we have. The greatest tool we have is the gospel in order to prevent crime. So, Father, help us to do your work and to do your will. Father, thank you again for Judge Kirby. Bless him as we've prayed, and I ask these things